Indian Partnership Act 1932 Chapter 1 Preliminary Section 1 to 3 Under Section 2B of Indian Partnership Act, business include every trade, occupation and profession. Chapter 2 Nature of the Partnership Section 4 to 8 State which of the statement is true. Partner is an agent of the firm. What is partnership at will? Partnership without the provision for the duration. A partnership is not for any fixed duration is partnership at will. Which of the following is a strong but not a sufficient test of partnership? Sharing of profits. In which one of the following case partnership exists? Several persons jointly purchase a good for resale without the view to divide the profit arising out of the transaction. In which one of the following cases a partnership does not exist? Lender of money receiving profit, servant or agent receiving profits, widow of a child of a deceased partner receiving profit, seller of the goodwill receiving profit. A partnership firm is not a distinct legal entity from its partner. A partnership can retire by notice of his intention to retire, where partnership is at will. In a partnership at will, a partner of a firm can retire from the firm at any time by giving a notice to his intention to retire of his co-partners. A partner of a firm can dissolve the firm at any time by giving a notice of his intention to dissolve the firm to his co-partner. Where the partnership firm is constituted for a fixed time, after the expiration of the time period, the firm continues to carry business without any agreement. The partnership became the partnership at will. As per Section 5 of Indian Partnership Act, relationship of a partnership is created by contract. Partnership means an agreement between the person share the profit or business carried on between them. In relation of the partnership, according to the Section 5 of Indian Partnership Act 1932, arises from contract. The mode of determination of existence of partnership has been laid down in Section 6. A partnership for which no period or duration is fixed under Indian Partnership Act 1932 is known as partnership at will. Which one of the following is not an essential requisite for creating a partnership as per Section 4 of the Partnership Act? Sharing of losses. An act to be called an act of a firm within the meaning of Section 2A of Indian Partnership Act 1932, only such act will give rise to the right enforceable by or against the firm. Which one of the following is a valid partnership? Partnership between two partnership firm, partnership between one firm and one individual, partnership between individual member of one firm and the individual member of another firm. The most important feature of the partnership at will is easily dissolubility. Chapter 3 Relation of partner to one another. Section 9 to 17. Goodwill of a partnership firm. Partnership business is the property of partnership under Section 14. If a partner chooses to use any asset of the partnership firm for his own purpose, it gives rise to the civil liability of the partner. Under Section 10, every partner has a duty to indemnify the firm for any loss caused to the firm by his task in the conduct of the business of the firm. Fraud. Where Jad as YW, as a partner of the stationery business, Jad ordered on the firm letterhead to supply 2 bags of weight and his resident. What will be the liability of the firm under India Partnership Act 1932? The firm is not liable to pay any debt. A partnership has no implied authority to enter into partnership with other person in any other business. An agreement in restraint of the trade of a partnership under Section 11 of the Partnership Act is valid. The historic case laying down the test for determining the existence of partnership is Cox versus Hickman. General duty of the partnership has laid down in Section 9 of the Act. Goodwill of a partnership business is a property of the partnership under Section 14. Chapter 4. Relation of partner to the third party. Section 18 to 30. The authority of the partner to bind the firm by his act done in usual course of the business is called implied authority. Such authority does not include withdrawn a suit or proceeding filed on the firm behalf. According to Section 30 of Partnership Act, at any time within 6 months of his attaining majority or obtaining knowledge that he has been admitted the benefit of partner, whichever date is later, the minor can elect to become not to become a partner of firm. Such option is exercised by giving public notice. If remaining silent and fail to give such notice, there is a presumption that he wanted to a partner. On the expiry of the said 6 months, he shall become partner in the firm. If he did not exercise the option, he will deem to be partner of the firm. Which one of the following section define doctrine of fielding out, creating the liability of non-partner under the Partnership Act? Section 28. A minor who has been admitted the benefit of partnership under Section 30, Clause 5 of Indian Partnership Act, the attending majority has been exercised any option to stay or leave the firm within 6 months of attaining majority. A firm can be held liable for wrongful act of the partner where the act has been ratified the partner provided by the act could be legally done with the authority of the partner. The partner ratify the act fully knowledge of the fact. Doctrine of folding out is mentioned in Section 28 of Indian Partnership Act. Which one of the following is not correctly matched? D. Partnership is defined under Section 4. Partnership at will is Section 7. Expulsion of partner, Section 33. Which is incorrect regarding the implied authority of the partner? He can compromise suit on behalf of the firm. He can transfer immovable property of the firm. He can enter into partnership on the behalf of the firm. By implied authority, each partner bind all other partners by his act, matter which are within the scope of the object of partnership. In partnership of general commercial nature, which one of the following is not within the implied authority of the partnership? That the partner may admitted liability in a suit against the firm. Which one is included in the implied authority are that every partner may place or sell partnership property, that every partner may borrow the money on account of partnership, that every partner may engage servant for the partnership business. If a person who is minor according to the law which he is subject to admitted the benefit of partnership, it is claimed that he can enjoy for some time the status of minority even after attaining the majority. Within how many months attaining the majority, a minor admitted into the benefit of partnership firm must decide whether he want to become a partner in the firm. 6 months. When a minor elect to become partner, he became the personal liable of the third party for all the act of the firm done since he was admitted to the benefit of the partner. Under Section 25 of Indian Partnership Act 1932, the liability of the partner for act in the firm is joint and severally. Applied authority of the partner as agent of the firm under Section 19 of the Partnership Act does not empower him to compromise and relinquish any claim of the firm, withdraw a suit filed on the behalf of the firm, admit any liability of the suit against the firm. Which one of the following sections of Indian Partnership Act bestow every partner with the authority of the agent as an agent? Section 18. When a minor who was admitted to the benefit of the partnership firm became the partner upon attaining the majority, he personally liable and commence from the date of the fact first admission of the benefit of the partnership. Chapter 5 Income and Outgoing of Partner, Section 31 to 38. Out of which one of the following is not correct statement regarding the retirement of the partner? Which one is correct? A partner may retire with the consent of all other partner. A partner may retire in accordance with the express agreement by the partner. C is wrong. Where the partnership is at will, a partner may retire by giving notice in writing to all other partners of his intention to retire. A new person can be introduced in the firm as a partner under Section 31 of the Act, unanimously consent of all the partner. In which one of the following cases a partner may cease to be partner without dissolution of the firm? Retirement, insolvency, death. Under the Partnership Act 1932, where a partner is at will, a partner may retire by giving written notice expressing his intention. Assessee of the truth or falsely of following statement by picking up a right option under Indian Partnership Act 1932. Consent of all existing partner, generally required for introducing a new partner into the firm. A partner may retire with the consent of all the partner of the firm. Generally, an introduction of the new partner in the partnership firm would require the consent of all the partner. On the death of the sole proprietor, he is here automatically became the partner of old firm. The statement is false. Chapter 6 Dissolution of Firm, Section 39 to 55. Dissolution of firm means dissolution of partnership between all the partners of the firm. A dormant is that partner who has never taken a part in the conduct of business as a partner but is liable to act in the firm. If an innocent partner seeks the dissolution of the firm under Section 44C of Indian Partnership Act 1932, he is satisfied the court that the conduct of the other partner is calculated to prejudice carrying on the partnership business. Compulsory dissolution of firm has been provided under Section 41 of the Act. Subject an act done by a partner in behalf of a firm beyond implied authority can be rectified by implied conduct. Subject to the contract between the partner, a firm is dissolved if it constituted for the fixed term by the expiry of the term, if he constitute the carry out one more adventure and undertaking the completion thereof by the death of the partner. A dissolution of firm can be claimed under Section 44E of Indian Partnership Act, where the partner has transferred the interest in the partnership firm to third party. A firm is liable for the compulsory dissolution under Section 41 of Indian Partnership adjudicated neither A nor B. A, B, C are the partnership in the firm of C. Retired, C retired, X admitted as a new partner. The firm did not give a public notice of the change but continued the business in its old name. Z, a customer of the firm, deal with the firm after changing a firm, become in debt to him. Z can sue A, B, C and X. Under Indian Partnership Act 1932, where the partnership at will, the firm may dissolve by any partner by giving a notice in writing of his intention to all the other partners. Chapter 7. Registration of the firm. Section 56 to 57. A partnership firm is required to be registered under Indian Partnership Act 1932. Registration of firm is not compulsory. A partner of an unregistered firm cannot sue the firm or any other partner of the firm to enforce a right arising out of the contract conferred by the Partnership Act. A and B are the two members of the three members of the partnership firm, being a suit to recover a debt due to X to the firm, but their firm did not register on the ground that institution of the suit is liable to be rejected with the view of Section 69 of Partnership Act. A partner of an unregistered firm cannot sue for enforcing the right under Partnership Act for enforcing the right arising out of the partnership contract. Which one of the following cannot claim the partnership as a matter of right? Right to receive remuneration. Miscellaneous. A partnership firm may be dissolved with the consent of all parties in accordance with the contract within the partner. The term goodwill is a thing easy to describe but very difficult to define, stated by Lord Mountbatten. Where the partner is authorized to recover due of the partnership and spend the same time for business of the partnership, and if he does not deposit the money so collected in the bank, the partnership is accountable civilly to the other partner. A dormant partner is one who neither is active nor known to outside. Which statement is correct? A partnership firm is not a distinct legal authority from its partner. If in which one of the following case the Supreme Court held that the firm is namely only the compendious way describing the partnership firm, Muralidhar versus Chunilal 1970. Under the Partnership Act 1932, where no provision is made by the contract between the partner for the duration of their partnership or for determination of their partnership, the partnership is called partnership at will. A partnership firm is none of the above. A, B, C enter into the agreement for the partnership at will. The partnership deed contain the following provision. Which one of the following provision of the deed is innocent with the partnership firm? That if the partner want to retire from the partnership, the notice of certain fixed time will be required for retirement. Registration of firm does not create a partnership, but if only evidence of the partnership true. The prepositions are where the partners of the professional business of partnership borrow money in the usual and regular course of business, stating that the money is be used to the partnership business but misappropriated, the other partner shall be liable. Under the Indian Partnership Act 1932, partnership does not work under the principle of limited liability. Which one of the following is not an essential feature of partnership? Separate legal entity. Upon the coming into the force of Limited Liability Partnership Act 2008, both the act coexist, but the provision of Indian Partnership Act is now applicable to Limited Liability Partnership Act save as otherwise provided.